First, it was her mother, because she'd asked about a wrongful death suit. Next, it was a brother with a missing gun, because according to testimony at trial, Sue Helm claimed that he had access to information to create the charge count in Mr. Foley's name. Now it appears to be Matthew Ruka, because he has a criminal history and he's related to the victim's sister by marriage. Your Honor, we don't believe that any evidentiary hearing is necessary in this case, and we're going to ask you to deny the defendant's motion.
Mr. Schaffer.
Thank you. Well, it's interesting that the prosecution is suspicious of this witness. If they're suspicious of this witness, I guess I'd like to know why. I certainly am not aware of any motive on this person's behalf to have done anything other than what she told me that she had done in relation to coming forward after the verdict. And I think an evidentiary hearing is going to allow the court to make its determination as to the genuineness of this particular person. I am not aware of any motivation other than that which I have expressed to the court why she came forward. I guess it's interesting that I guess the prosecution is suggesting that I have set this up because I have had requested a FOIA on Matthew Ruka. Matthew Ruka, in my estimation, was a suspect in this particular matter because the police had rushed to judgment and had one suspect. We presented 4, and Matthew Ruka was one of the suspects that we had thought was involved in this particular matter. And that came to fruition when we received by subpoena the Ruka name on the false credit card. Yes, I had requested the FOIA before in an effort to get a picture of Matthew Ruka beforehand, but we had Mr. Brownell who was not able to recognize who he had seen coming out. That FOIA was there. We had done more investigation on Matthew Ruka than that, but it became clear that we were not going to be able to get an identification from any witness that we knew about until Mrs. Moore came forward, and that at time when she indicated that she could recognize who she saw, it was the opportune time to deal with that issue.
Mr. Schaffer, do you have any evidence at this point that he was not in custody during
I have, subsequent to receiving the answer, I have checked, Your Honor. At this point in time, I do not. I have checked with the Indiana facility, and I am not able to come up with it. I talked to the people down there at that particular time. Although they have some sort of furlough circumstance down there, I am not able at this point in time to represent to the court that he was on furlough on that particular date. I do not at this moment. Your Honor, regardless of the Ruka connection, this is new evidence. It is not the same. It's 45 minutes different. I submit it's a different car. It's a car that is not doing the same thing as the other car. So I submit it's not cumulative. And this is a circumstantial case that we're trying to prove a negative on the defense. We have a case with no murder weapon. We have no eyewitnesses. We have a lot of evidence that does not exist, and some that does exist that shows that the defendant did not participate in this. And this is another lead of circumstantial evidence that I believe that the jury is entitled to hear to make their determination.
Well, as to the element of the motion seeking motion for new trial based on the verdict being against the great weight of the evidence, that, in my view, is identical to that already ruled on by the court in the motion for directed verdict, and the court will adopt its findings in denying that motion. As to the motion for newly discovered evidence, or for new trial based on newly discovered evidence, first I note a clarification in the affidavit of both Ms. Moore and Mr. Koberstein, the affidavit of Ms. Moore states that the photograph she was shown of this person could be, quote unquote, the person driving the car. She did not make a positive identification photograph. And Mr. Koberstein's affidavit detailing his showing of that photograph to Ms. Moore states, quote, at that time she indicated the photo strongly resembled the person that she observed driving the vehicle out of the Foley driveway on February 7, 2009. That, I think, is important in deciding the next course of action with respect to this motion. If her affidavit and Mr. Koberstein's affidavit had contained a positive identification, a purported positive identification of Rourke, which was substantially rebutted by the prosecution's affidavits that he was in custody during all of that time, I'm satisfied I'd have enough evidence before me without further evidentiary hearing to rule on the motion immediately. Given, however, that she did not make, at least from the evidence before this court, a positive identification that the person she saw leaving the driveway was a person now turning out to have been in custody at the time, I'm satisfied that the law requires an evidentiary hearing to test her testimony under cross-examination as to at least two of the elements of the relief that is sought, that is, whether the evidence is newly discovered and whether it is plausible to the extent that it is likely that a different result would be had at a retrial before a different jury hearing the newly discovered evidence. And so for that reason, the court will set an evidentiary hearing at which it will be, now post-verdict, the defendant's burden to establish the grounds for the relief sought, that is, a motion for new trial based on newly discovered evidence. I'll confer with counsel as to an appropriate scheduling for that. I have some dates available which can be hopefully meshed with counsel's schedules and dockets to accomplish that. So that motion is under advisement. That is, the motion for new trial based on newly discovered evidence is under advisement. The other motions filed by defense are denied. I find no reason for delay of sentence. The defendant is entitled to the same relief if he prevails, pre versus post-sentence, and it is my intention today to proceed with sentence. Let's do so. The court has received a proposed pre-sentence report dated December 9th. As well as a recommendation of sentence, and supplied in part, I believe, by the probation department and in part by the prosecution, a number of victims' impact statements in writing. First of all, on behalf of the people, Ms. Norris, do you have any objection to the pre-sentence report?
None.
Mr. Schaefer, do you?
The pre-sentence report, I have no objection. I have one typographical error which is not significant but ought to be accurate. On page 6, last paragraph should be 1991 rather than 1992, pursuant to my client's information. Otherwise, the...
I'm sorry.